court has refused to compel Buhari to enforce Benue's anti-open grazing law. A federal high court in Abuja on Thursday rejected a suit that sought to compel President Muhammadu Buhari to instruct his security agencies in the country to enforce the Benue State open grazing prohibition and ranching law passed in 2017. Justice Ijeoma Ojukwu, in a judgment read during a virtual court proceeding, said a court lacked the jurisdiction to entertain the suit brought by the plaintiff and proceeded to strike it out. The plaintiff, Matthew Tile Inusa, who said he is a lawyer and indigene of Benue State, had sued President Muhammadu Buhari, claiming that the president, by his oath of office, incurred a mandatory obligation to uphold and preserve the law of the land, but has failed to abide by his oath when he refused to implement the Benue State open grazing prohibition and ranching law. Isa added that despite the existence, elders have remained unrelenting in practicing open grazing, engaging in killings and destructions, but that the president has failed or refused to enforce the law in view of his oath of office by using the security and enforcement apparatus within his powers. In her judgment on Thursday, Justice Ojukwu held that the failure of the president to discharge his official responsibilities in accordance with his oath of office is not justifiable, and that the court cannot hold the president accountable for not abiding by his oath of office. In my view, the courts do not have the verse to entertain any suit bordering on compliance with the oath of office of the president to the reason that it is not justifiable. When the person, in this regard, the president, fails to abide by the oath, the National Assembly, in line with the set-down procedure, may consider its misconduct in the performance of the functions of his office and take the appropriate measure under the Constitution. It is not the duty of this court to adjudicate on it. The plaintiff may have genuine concern in respect of the facts averred, but there are procedures set out by law to address issues concerning citizens' rights and violations. There is no contest that the open grazing prohibition and ranching establishment law 2017 was validly passed by the Benue State House of Assembly and that the law is still in force, especially as the law has not been struck down by any court of law or court of incompetent or jurisdiction. The implementation, therefore, lies with the machineries of the state and law enforcement agencies like the police, whose duty is to maintain law and order and to secure lives and properties, is in accordance with Section 4 of the Police Act. It behooves the people of Benue State and law enforcement agencies, task force, etc., to employ all legitimate means to implement that law. Well, in this issue, it's not it has procedure. Yes, we agree, but when it comes to paid salary or the Senate or allowance or anything that has to do with them on the high side or the representatives of assembly, they quickly address the issue. If it's any issue bothering them, they quickly address the issue. But now it comes to just the local chamber, the local people, the masses. They will waste time. They will say it's in procedure. There are procedure. They will start delaying the position, adjourning cases till that thing fades off and it's not being executed. This government is doomed. Well, it is not the duty of the defendant on record. It is only where there is an infraction of the provision of that law that the courts may be invited to impose the prescribed sanctions. Insofar as the president has not issued any executive order which runs contrary to the said law, these courts cannot hold him accountable. In the same vein, the court is not the appropriate arm to check any infraction in the performance of the functions of the office of the president arising from the oath of office taken by the president on the assumption of his duty as the president of the Federal Republic of Nigeria. That duty or obligation belongs to the National Assembly through the process prescribed by the Constitution, the judge said. Justice Ojukwu equally held that by the provision of Section 308 of the Constitution, the plaintiff was wrong to have sued President Buhari in his personal capacity on an issue that relates to the performance of his official responsibilities. The immunity provided in Section 308 of the Constitution is protecting the occupier of the office named in the section against the institution of either civil or criminal suit against him or her in the section from being sued in his personal capacity while in office. She said although the suit was in relation to the responsibility of the president in his official capacity, the plaintiff went outside that official capacity by adding the personal name of the name Buhari Muhammad to the suit as a defendant. The proper defendant in this case ought to have been the President, Federal Republic of Nigeria. The life of this suit cannot be sustained if, for any reason, President Muhammadu Buhari ceases to be in office. This suit will automatically obey since it cannot be sustained by any other president. His personal name haven't been attached. This cannot be position of the law since governance is a continuum and does not determine or terminate because the tenure of office of a particular office holder has elapsed. The proper defendant in this case on the alternative should have been the Attorney General of the Federation and the defendant on record Buhari as a nominal party, or in the alternative the President, the Federal Republic of Nigeria, Justice Ojukwu has just said. Well, reaction has been trailing. That doesn't translate to mean that the anti-grazing law is ultra-vires, null and void. Akeredolu and others will take a dime view of the judgment and will effectively enforce the same law at state level. Shebi, let me use that word. Shebi Malami said the anti-open grazing or open grazing issue or any restructuring that will start or should start from the state. And meanwhile, Lawan said if they want to enforce any law, they should rather start from the state government. I believe the governors of South have really met in their meeting and they have talked about open grazing. And I thank God that everything is working out fine. If it were to be left to the federal level, they will just, rub it. Like I said earlier, they will adjourn. If it's a case that is disturbing them directly, if it's their case directly, they will know how to settle it. They will know how to, quickly attend to it. But when it comes to the state level or the local level, they will abandon it. They will start rubbing it, telling us all sorts of stories that is not constitutional. There are procedures, there are steps, there are this, there are that. And now that is in their own favor, or maybe in their own, it's not their own directly. They will delay. They will, tell us stories.